Hello and welcome back to the Florida Rights Institute informational video series. We're going to be going over the Florida firearm waiting periods, an overview of the waiting periods for purchasing firearms in Florida. The following presentation is meant for informational purposes only and is not intended as legal advice. Seek a licensed attorney if you need legal assistance. The waiting period rules are both in the Florida Constitution and in the Florida statutes. Florida Constitution Article 1, Section 8b, the right to bear arms. Florida Constitution Article 8, Section 5b, the local option. And Florida Statute 790.0655, purchase and delivery of firearms, mandatory waiting periods, exceptions and penalties. There are also local laws at the county level, which we will cover briefly as a generality. Florida Constitution Article 1, Section 8, subsection B states, there shall be a mandatory period of 3 days, excluding weekends and legal holidays, between the purchase and delivery at retail of any handgun. For the purposes of this section, purchase means a transfer of money or other valuable consideration to the retailer, and handgun means a firearm capable of being carried and used by one hand, such as a pistol or revolver. Holders of a concealed weapon permit, as prescribed in Florida law, shall not be subject to the provisions of this paragraph. This section applies to handguns, like pistols and revolvers. Obtaining a concealed weapons permit allows someone to avoid the waiting period for handguns. Otherwise, you will have to wait at a minimum 3 days to obtain a handgun under this provision, which excludes weekends and holidays. So if you buy on a Saturday, and Monday is a federal holiday, you won't get the handgun until Friday because Saturday and Sunday don't count as they are weekend days, and Monday is an official government holiday. Note, this section must be read along with the other constitutional and statutory provisions to understand the nuances of application. Florida Constitution Article 8, Section 5, subsection B states, each county shall have the authority to require a criminal history records check and a 3 to 5 day waiting period, excluding weekends and legal holidays, in connection with the sale of any firearm occurring within such county. For purposes of this subsection, the term sale means the transfer of money or other valuable consideration for any firearm when any part of the transaction is conducted on property to which the public has the right of access. Holders of a concealed weapons permit, as prescribed by general law, shall not be subject to the provisions of this subsection when purchasing a firearm. This provision reiterates that CWP holders are exempt from waiting periods, and it's a good reminder that a CWP may be a wise choice to avoid waiting periods. However, it notes that counties may pass ordinances to require criminal record checks and/or a 3 to 5 day waiting period for any, yes, any type of firearm purchase on property to which the public has right of access. This provision was meant to address gun shows held at government buildings or convention centers. However, it can apply to any public place where the transaction occurs. Private property is where the public generally doesn't have the right of access, only a permission or license to enter unless notice is posted otherwise. So in other words, private sales on wholly private property would not be the subject of this restriction. What Article 8, Section 5 essentially means is that if you do not have a CWP, you should be careful to check your county's rules on firearm sales so that you do not run afoul of or become inconvenienced by the local laws on criminal background checks and waiting periods. This is especially important if the private sale is taking place in an area the public has a right of access to and the buyer does not have a CWP. Record checks here would typically be run by a federal firearms licensed dealer, FFL, and the choice to run that background check is up to the dealer. In other words, they are not obligated to serve you. The dealer can also charge a fee for the record check and a service fee on top of that, as the ATF has ruled that they must inventory the gun when performing the National Instant Criminal Background Check before transfer. The Florida statutes also have commentary on this under 790.0655, the purchase and delivery of firearms, mandatory waiting periods, exceptions, and penalties. It states in subsection A1A, a mandatory waiting period is imposed between the purchase and delivery of a firearm. The mandatory waiting period is 3 days, excluding weekends and legal holidays, or expires upon the completion of the records checks required under section 790.065, whichever occurs later. Purchase means the transfer of money or other valuable consideration to the retailer. Retailer means and includes a licensed importer, licensed manufacturer, or licensed dealer engaged in the business of making firearm sales at retail or for distribution or use or consumption or storage to be used or consumed in this state as defined in section 212.0213. Note that this section says whichever occurs later on the 3-day waiting period versus the record check. It is unlikely that a record check would take more than 3 days. Usually it's less than a few minutes. So the 3-day period is your most likely situation. This section repeats some of the information from Florida Constitution Article 1, Section 8, but notes some special exceptions to the waiting period. CWP holders, of course, like noted before, a trade-in of another gun. And note here, only the gun can be traded. If there is money in the transaction, it falls under purchase. A purchase of rifle or shotgun after completing the 16-hour hunter safety course and holding a hunter safety certification card. If someone is otherwise exempt from taking the course, then having a valid Florida hunting license would exempt the purchaser as well. And also, when the purchase is by a law enforcement officer, corrections officer, or service member, as defined in the Florida statutes, this section does not apply to their purchase. In summary, obtaining a CWP is likely the best option to avoid the headaches of waiting periods as a buyer. If you do not have a CWP, then you must especially take note of the local county rules when planning a purchase to ensure that you do not run afoul of the law as a buyer or seller, or otherwise be inconvenienced if you're planning a hunting or range trip soon after a purchase. Violations of the provisions can carry felony charges, so be safe and seek a licensed attorney if you have questions related to your specific situation. Thank you so much for watching this Florida Rights Institute informational video series. For more informational and educational videos, please subscribe to this channel and visit www.floridarights.org.